Hi, I'm attorney Renee Osipov with Chelle Law, and we assist nurse practitioners with employment contract issues. Today, I'm talking about the differences between a non-solicitation clause and a non-compete clause. To start, both of these, the non-solicitation and non-compete clauses, are typically located in a similar spot in your employment agreement, and it's normally under the restrictive covenants. Restrictive covenants just means it's a promise not to do something. So you're promising not to solicit either patients or employees after you leave. And then a non-compete clause is you're just promising not to compete with your employer that you have terminated your agreement with. So let's start with the non-solicitation clause. Non-solicitation clause really has about three parts. So the first part is how long you are restricted for. Normally, a non-solicitation clause is going to be a 1-year restriction. That's what we mostly see within our practice. So you're going to be restricted for 1 year from soliciting or reaching out, enticing, trying to poach former patients or former employees. And what does this mean? So it means you can't reach out to them directly. Now, if you are leaving, you can absolutely let your patients know, that you're leaving. You can let employees know that you're leaving. If they ask you where you're going, you don't have to withhold that. You can absolutely let them know. You just get in trouble with these clauses, and you would be violating it if you're reaching directly out to those patients, like sending letters to them stating this is where you're going, and, if they want your services, they can come with you. That would be in violation of a non-solicitation clause. Another part of the non-solicitation is, who's restricted. So like we said, patients, former patients. Sometimes it will say, if they've been a patient within the last year prior to your termination, something like that. And then employees. And you want to be careful with the employees because sometimes I have seen in non-solicitation clauses, you want to read them really carefully. Sometimes you're prohibited actually from hiring former employees. Now that's tricky. So that means if you're opening up your own practice, you're actually restricted from hiring them. That's even if you don't reach out to them. So you want to make sure you're reading your employment contract very carefully. Now, general advertising. So if you're advertising to the masses, billboards, social media, commercials, that's not really considered, in my opinion, soliciting those former patients or employees. It's just general advertisement. You're letting people know like this is where you are and these are your services. If you have mailing list and you're directly targeting your former employees or the former employees or former patients, then you're probably going to get in trouble with the non-solicitation clause. The other thing you should be aware of is sometimes in the non-solicitation clauses, it says you cannot solicit directly or indirectly. And they don't really define what indirectly means. You want to be careful there because that's a very vague term and that you're protecting yourself. So that's something clients ask to get defined a lot from your employer. So that's the non-solicitation clause. You're restricted for a period of time from reaching out, soliciting, enticing patients to either come with you for your services or employees to become employed by you or with you. Now, the non-compete clause is a little different. So there's normally two parts to the non-compete clause. So one, you're restricted for a certain period of time that's stated. And again, that's normally 1 year, but I have seen it try to go up to 3 years. In my opinion, anything over 1 year is kind of unreasonable. So you're restricted from a period of time from providing services within a certain area. And normally it's in a radius of miles. Sometimes it's city blocks, depending on your state law. I've actually seen counties or parishes, but it just kind of depends. So for a period of time, you're restricted from a certain area for providing your services. The non-compete clauses, you want to be careful because you want to know what locations is that restricted area attaching to. Sometimes it can be multiple locations. In my opinion, it should always be only your primary location where you yourself are located, your home base. But sometimes, though, they can attach if you provide services at any location. So if you fill in for someone while they're sick or on vacation, that non-compete then attaches to it. And then lastly, sometimes I have seen companies that state any location of where they have a practice, then you're restricted. And you want to be really careful there because you're restricted from areas that you're not even providing services at. So always, again, read your employment agreement very carefully. Non-solicitation and non-compete clauses are normally enforced the same way. It's normally called equitable relief, which just means that your former employer would bring your employment contract before a judge. If they found that these clauses were enforceable, they would sign an injunction or a restraining order, which just means that there would be a legal document stating a court order that you could not work within that area or you could not solicit those patients or employees. If you'd like more information, you can check out our website at Chelle Law, CHELLE law.com. We have attorneys who are happy to assist reviewing your employment contracts and answering any questions you could possibly have on those agreements. And feel free to reach out.